Rules Committee come to order, and good afternoon, and welcome to another fun day at the Rules Committee. Today we have an exciting panel with two very experienced members who take time to visit the Rules Committee often. We welcome the young chairman of the Financial Services Committee, the gentleman from Dallas, Texas, Mr. Henserling, as well as the gentlewoman, my dear friend, Ms. Waters from Los Angeles, and that we're delighted that you're here. The Rules Committee today will be considering H.R. 3971, the Community Institution Mortgage Relief Act of 2017, and H.R. 477, the Small Business Mergers, Acquisitions, Sales, and Brokerage Simplification Act of 2017, and House Joint Resolution 123, which will be the second part of the hearing today, the Continuing Appropriations Act of 2018. M&A brokers provide necessary services for small private companies that are looking to merge and or to be acquired. But M&A brokers can face substantial compliance costs associated with a one-size-fits-all regulatory scheme associated with broker-dealer registration. Costs that ultimately, once again, just get passed down to small private companies and puts them in need of not only those services, but then having to pay those bills. H.R. 477 helps alleviate the most costly burdens on small companies by allowing M&A brokers to have simpler, less costly regulation requirements. And doing so will facilitate liquidation in small businesses, which help preserve and ultimately create jobs, and I think save wealth for people who've worked hard in the marketplace as they make transitions that are associated with the life of their company. The committee today will also consider H.R. 3971, the Community Institution Mortgage Relief Act of 2017, another piece of legislation out of the Financial Services Committee. This legislation amends the Truth in Lending Act and the Real Estate Settlement Procedures Act of 1974 to modify the requirements for community financial institutions with respect to certain rules related to mortgage loans and for other purposes. This bill benefits small financial institutions and consumer protections by allowing community banks to serve the local economy through relationship banking. It also ensures constituents continue to have access to various credit choices and allow other similar community institutions to enter the mortgage market without being deterred by the high cost of regulatory compliance. Once again, remembering that the costs get passed on to the consumers that we want to be able to have not only the housing, part of the American dream, but to be able to get the cost in the house that they can sustain over the long run. Rules Committee will also be considering, as I spoke about, the Continuing Appropriations Act of 2018. It's a really relatively short, page and so, piece of legislation that deals with the continuing resolution, which will extend government funding through, as we have all been told, December 22nd, 2018. I believe that's a Friday night, Mr. Chairman. So without objection, I'd like to welcome the distinguished gentleman from Texas, Chairman Jeb Henserling, as well as the distinguished gentlewoman from California, Ranking Member Waters, to the panel. And as always, you've been here a lot. You're a star witness many times. You'll remember that without objection, anything you haven't write in, we'd like to have you lead it for our awesome stenographer to complete the record accordingly, aiding to support your testimony. However, before we move further, I'd like to recognize the gentleman from Florida, the ranking member of the committee, for any opening statements he'd like to make. The gentleman.
Thank you very much, Mr.
Yes,
Chairman.
sir.
I'm happy to see a bipartisan amendment offered that addresses many of the concerns that we have on both sides of the aisle, and I understand that Ms. Waters, the ranking member, will support this bill if this amendment is made in order and ultimately adopted. As pertains to the continuing resolution, I would borrow from Ms. Lowy and ask the question, what you believe you can accomplish in the next 2 weeks that you haven't been able to accomplish in the last 2 months. But I'll get a chance to ask that question, but principally that 2 weeks from now, we're going to be here again discussing another fix. And I've already heard that we'll be back to do another short-term CR at the end of this year, going through mid-January. And my belief is we ought to do that one now rather than be bouncing back and forth during the holidays. Thank you, Mr. Chairman.
Yes, sir. Well, the gentleman is correct. There are answers that abound. We have 2 star witnesses today that will work us through the 2 pieces of legislation, the most immediate from financial services, and our 3rd witness on the CR ain't much of a guy. It will be me, but I will attempt to do my very best to answer the gentleman's questions to move forward so that we may have this on the floor and resolve, at least for the short term, these items. And I thank the gentleman very much. Mr. Chairman, we're delighted that the chair. Gentleman's recognized.
Thank you, Mr. Chairman and members of the Rules Committee. And as the chairman and ranking member of the House Financial Services Committee, we have many stars on our committee on both sides of the aisle, and we are happy to represent them today. Mr. Chairman, thank you for the opportunity to appear before you yet again to testify on behalf of 2 bipartisan bills that were favorably reported out of the Financial Services Committee and have a strong track record of bipartisan support. Today we'll discuss H.R. 3971, the Community Institution Mortgage Relief Act, and perhaps spend a little less time discussing, for the reasons articulated by the gentleman from Florida, H.R. 477, the Small Business Mergers, Acquisitions, Sales, and Brokerage Simplification Act of 2017. H.R. 3971 addresses concerns that the CFPB's rules implementing Dodd-Frank Act provisions on escrows and mortgage servicing are overly burdensome for our small banks and community credit unions and unfairly restrict consumers' access to mortgage credit. All this bipartisan bill would do is simply relieve smaller banks, certain smaller banks and credit unions of the obligation to provide escrow accounts if they have consolidated assets of $25 billion or less and hold the mortgages on their balance sheet for 3 years. Loans held in portfolio by community financial institutions should be exempt from such requirements because when the loans are held in portfolio, lenders have every incentive to protect the collateral by ensuring that taxes and insurance payments are made and kept current. A large majority of community banks do not currently escrow because of the cost, and requiring them to do so will only stop them from making loans to many needy individuals. A community banker in Missouri told us the CFPB's rule has forced his bank, quote, to limit in-house residential real estate lending, unquote. He went on to further say, this is hurting the housing market in our community. A credit union official in Pennsylvania told us that this bureaucratic requirement has caused his credit union members to become, quote, very upset and confused as to why they were unable to pay their taxes how they always had. And he went on to write us, quote, these members had managed their tax and insurance payments for years without institution interference, but suddenly feel like the government now told them they were not responsible enough to manage their own affairs, unquote. The important corrections in H.R. 3971 will give small credit unions and community banks greater flexibility to ensure that more of their members and customers can get a loan to buy a home and stay in their homes to ultimately make credit more available and less expensive than it otherwise would be. I have further comments prepared on H.R. 477, but given that the ranking member and I are recommending to the Rules Committee, and should they see fit, to make in order the Sherman Amendment, we will both support that amendment, and if so, the ranking member, I believe, has informed us she is prepared to support the underlying bill. That is the recommendation we make to Rules Committee. So unless there are questions on H.R. 477, in the interest of being efficient with the use of the time of the Rules Committee, I will not make introductory comments on that, and I appreciate again, Mr. Chairman, the opportunity to appear before the Rules Committee, and I'll yield back.
Mr. Henschling, thank you very much. We appreciate not only your testimony, but bringing these bills forward that would allow listening to these community banks, bankers, credit unions, the needs that they need to fulfill customer demands in the marketplace. We're delighted, Maxine, that you're here and the gentlewoman's recognized.
Thank you very much, Mr. Chairman and members. On H.R. 3971, this bill would allow a large number of mortgage servicers to drop important consumer protections and set the stage for a return of the harmful practices of the subprime meltdown and the worst financial crisis since the Great Depression. Specifically, the bill would harm consumers by raising the Consumer Bureau's exemption threshold on escrow account requirements for higher price mortgage loans. Mortgages are classified as higher price if the annual percentage rate, or APR, exceeds the average prime offer rate by 1.5%. Higher price mortgage loans often reflect riskier or subprime borrowers. Current Consumer Bureau rules require that most borrowers with higher price mortgage loans escrow their homeowner's insurance, property taxes, and private mortgage insurance for at least the first 5 years of their mortgage. Escrow accounts are an important consumer protection mechanism, especially for higher risk borrowers, because they ensure that homeowners have funds for these expenses, thereby reducing mortgage defaults or loss of the property. Escrow accounts also keep homeowners from being blindsided by additional costs at the end of each year and provides a more accurate monthly cost estimate for home ownership when the loan is originated. Dodd-Frank tasked the Consumer Bureau with implementing mortgage rules under the Truth in Lending Act that would restrict the types of practices that led to financial crisis. That is why the Consumer Bureau's rules are designed to ensure that homeowners understand and can meet the full cost of home ownership. The Consumer Bureau was careful to draft its escrow requirements to address the fact that large servicers, and especially servicers that service loans they did not own for an extended period of time, often did not adequately communicate with customers or appropriately track paperwork. During the crisis, this contributed to millions of unnecessary foreclosures and later on, several billion-dollar settlements for abusive and fraudulent business practices. Proponents of this bill say that it would provide relief from overburdensome regulation of small services, but currently, banks with less than $2 billion in assets that serve rural or underserved areas are already exempt from the Consumer Bureau's escrow requirements, which reflects the Bureau's commitment to balanced and tailored regulations. This bill would make a dramatic leap from the Consumer Bureau's targeted relief and exempt banks up to $25 billion in assets from escrow requirement, regardless of whether they are serving underserved borrowers, and without any evidence that this large exemption would increase access to credit for those who need it. The Consumer Bureau also provides other flexibilities through either exemptions to or adjustments from the RESPA mortgage loan servicing and escrow account administration requirements for small bank services, provided they and their affiliates own the loans they service and service no more than 5,000 loans per year. H.R. 3971 would increase this exemption by 500% from 5,000 loans a year to 30,000 loans, allowing significantly larger bank servicers to avoid these important consumer safeguards and only requiring the lenders to hold the loans in portfolio for 3 years. Let's be clear, homeowners do not get to choose their own mortgage servicer, and the least we can do is ensure that they are adequately protected as they navigate the system. As we saw leading up to the 2008 financial crisis, servicers often choose profits over people, and that is why we need the Consumer Bureau to look out for the needs of consumers. The Consumer Bureau has continued to do its job in spite of the unrelenting Republican campaign to slow it down or eliminate it completely. Simply put, 3971 would enable larger servicers whose incentives are not aligned with the owners of the loans or the borrowers to be able to revive the abusive practices involved with predatory lending that contributed to the 2008 financial crisis. This is the second time in less than 2 weeks that I've come before you to discuss a bill that would erode vital consumer protections under the Truth in Lending Act for borrowers with high-priced mortgage loans. I cannot support legislation that would keep consumers looking at high-cost mortgages from the vital protections and scrutiny they deserve. Although I understand that Mr. Sherman will offer an amendment to lower the exemptions provided for in this bill, I continue to oppose the bill because it would erode the work of the Consumer Bureau and undermine the consumer protection in home ownership. And I must note that this bill comes on the heels of the recent and unlawful takeover of the Consumer Bureau by the new OMB director. Mr. Mulvaney is in the process of unlawfully restricting the activities of the Consumer Bureau and will soon begin rolling back consumer protections. Congress should not be complicit in these acts by passing legislation that further erodes the rights and protections of America's consumers. For all these reasons, I oppose H.R. 3971 and look forward to answering any questions you may have. Thank you, Mr. Chairman.
Yes, ma'am. Thank you very much. Mr. Chairman, there was a question that the gentlewoman just brought up about the illegality of an action by the President of the United States to actually appoint the gentleman, Mr. Mulvaney, as the acting director. It was my understanding that this went to court and a court decided the remedy. Is that correct?
Well, yes, Mr. Chairman, and in fact, the CFPB's own legal counsel that was appointed by Mr. Mulvaney's predecessor, Mr. Cordray, agrees that the President gets to appoint the acting director. This is based upon a 20-year-old statute. It is the opinion of the Justice Department, it is the opinion of the CFPB, and it is the opinion of the one circuit court, the Ninth Circuit, a very liberal circuit, that is opined on the matter of the Vacancy Reform Act. And so the overwhelming legal precedent in this land says that the President gets to appoint the acting director. And what is also very disconcerting, Mr. Chairman, even if the President didn't have that authority, nobody debates that he has the authority to appoint the permanent director. And we also know that under the current conventions of the United States Senate, that permanent director can be confirmed with 51 votes, not 60. And the permanent director could undo anything that the interim director did. So regrettably, this is not helpful to democracy. It is not standing on firm legal ground. It doesn't help democracy. It doesn't help our economy. It's not on good, firm legal ground, and it is very, very unfortunate that it has happened and is keeping the work of the CFPB from going forward.
Well, thank you very much. Yes, ma'am.
Mr. Chairman, if I may speak to this issue.
I would ask you the same question. The gentlewoman reiterated her opinion that this was an unconstitutional use of direction. Gentlewoman have an opinion about that?
I do, Mr. Chairman. Mr. Chairman, if you take a look at and read Section 1011 of the Dodd-Frank Reform Act, you will find that the language is the deputy director shall serve as acting director. So Mr. Cordray, in his role as director, appoints the deputy director. And that deputy director, according to Section 1011 of Dodd-Frank, would then act as acting director in the event the director leaves, is not in a position to serve, or something happens that keeps him from carrying out his or her duties. And it is not may, it is shall. And I believe that the intervention by the President in sending over Mr. Mulvaney is in direct violation of Dodd-Frank Section 1011 and the language that clearly indicates the deputy director shall serve as acting director.
Mr. Chairman?
Well, again, Mr. Chairman, there are numerous statutes to be found in the federal code dealing with succession, but courts have opined that it is the president's option on which statute to avail himself of, number one. Point number two, my friend the ranking member quoted or paraphrased from Dodd-Frank, but if you read carefully the passage of Dodd-Frank that she cites, it speaks to the absence or the unavailability of the director, not the vacancy. And many other succession statutes specifically mention the term vacancy. And our former colleague and former chairman of this committee, Barney Frank, was recently quoted as saying, well, perhaps I paraphrase, the statute could have been more clearly written. So again, you will not find the word vacancy in this section. Mr. Cordray the director is not absent, the director is not unavailable. There is no director. He resigned the office to pursue his political ambitions back in Ohio. And again, the only court that has opined on this has opined in the president's favor. The legal counsel of the CFPB itself has ruled and opined in favor of the president. This is just an unsupportable position to take. It is unfortunate. I think it is derived from people who still haven't accepted the outcome of the last election. And I think it comes from a realization that the statute underlying the CFPB is a flawed statute. And so in some respects, we ought to take this beyond a fight between President Trump and President Obama. And it really shouldn't even be a fight between the right and left. It ought to be a fight between what is right and wrong. And we have an agency that is probably the single most powerful, unaccountable agency ever written into law, one of two agencies that I'm aware of that have ever been found unconstitutional, at least in my lifetime. And there are serious problems where this agency has eroded separation of powers, checks and balances, due process. And for anybody who is a Democrat, lowercase d, I would think that they would be absolutely aghast at the power this agency has. And so now all of a sudden, when they see this tool that they created in the hands of President Trump and our former colleague Mick Mulvaney, it sends shivers down their spine. So I hope maybe they will work with us on a bipartisan basis to reform this agency so it really can engage in the true business of consumer protection and do it in a way that is commensurate with our checks and balances and our democratic values.
Mr. Chairman, thank you very much. Also, we could add much about some of the problems that exist at CFPB, including personnel problems that abound. So it's my hope that—
How much time do you have, Mr. Chairman?
Yes, sir. So it would be my hope that the President of the United States appoints someone with the knowledge and the desire to make sure that they are structurally constructed in such a way that would conform to the needs of the Constitution, and that the agency would be conformed to present itself in better light in their financial decisions and their decisions that are made by personnel and the success of the organization. I could think of a few people that might fill that bill, and I will continue to hope that the President of the United States receives input on that. Mr. Cole?
Thank you, Mr. Chairman. I bet we have exactly the same person in mind.
I don't doubt that at all.
Well, it's good to see both my friends. They're always great members, and it's nice to— I know you have some differences on some issues, but it's also nice to see the measure of bipartisanship as well. I hope it becomes infectious around here. It would be nice to see a little bit more of it as we move toward the end of the year. But I congratulate you both on the bipartisan measure that you're bringing forward. I don't really have any questions. I just want to— there's still a few days left, Chairman Hensling, where you can change your mind and file in Texas. So that's the Christmas present I want. If this other one doesn't come to pass, I would much prefer my friend stay. But I wish him well. Thank him for his hard work, and I know he will continue to work hard on behalf of his people as he finishes out his term, unless unless we have that Christmas miracle and you decide that you're going to stay in Congress, which I wish you would do. With that, I yield back.
Distinguished gentleman shares my remarks to a T, and I thank the gentleman for his comments. Mrs. Slaughter does take time. Judge Hastings, do you
I
seek
have no
time?
questions, Mr. Chair.
Does the gentleman from Colorado seek time?
No, I don't, thank you.
Gentleman does not seek time. Does the distinguished gentleman from Georgia seek time?
I do, Mr. Chairman.
Gentleman's recognized.
Thank you, Mr. Chairman. I wanted to point out that not only do we have a piece of bipartisan legislation here, but we have a piece of legislation on which folks genuinely and not politically disagree. I thought the ranking member's comments trying to protect home buyers from being blindsided at the end of the year by a tax bill were very sincere and telling that we're talking about how to protect people from losing their home, and for folks who are not accustomed to buying a home, accustomed to seeing an annual tax bill, having one show up at the end of the year could absolutely blindside them. I confess I never had crossed my mind that we would require more escrow as a tool to prevent folks from being surprised in that way. The chairman said, for Pete's sakes, we're talking about local credit unions and small community banks, not that are pawning these loans off on into some pool, but who are keeping these in their portfolio, who are trying to nurture these home buyers. So often we come to the Rules Committee, we have a political conversation on things in which we just entirely disagree fundamentally about what the goal of the bill is. To have the two of you sitting here together saying we both have a real interest in protecting local consumers, we could do that through a CFPB regulatory process, or we could do that by putting consumers in the hands of their neighbors and their local financial institutions. I thought was a refreshing change for me as a Rules Committee member. So I just want you to know, you may not have come here to lift me up today, but you did, and I thank you for it. I hope that's going to. Thank you, Maxine. I just keep on going. There's more space there. We had a tough day in here yesterday. I feel better. About today, Mr. Chairman. I thought just sitting beside Tom Cole was going to be hard because we've got a tough New Year's Day coming up together. But I found that to be more rewarding than I expected it to be, and I have found this hearing to be more rewarding. So I thank you. I yield back.
Well, sooner or later, those dogs will get a chance. The gentleman does not seek time. You did catch on to that sooner. Okay, that's sooner. I know you did, Mr. Chairman. Mm-hmm. The gentleman from the great state of Washington, Mr. Newhouse. Thank you very much. It's good to see you today, Dan. Okay. I see, but there are no further questions of the esteemed panel. I would remind you, please recall that we have an awesome stenographer, and if you would please leave whatever you've got in writing and allow her to complete her record appropriately.
Excuse me.
Yes, ma'am.
I want to make sure that we have all of the information on 477 on the record. Did you do 477 also? You did 39.
I spoke of 3970.
Yeah,
I'm
you
not
did.
sure what you're trying to do.
We had two. Yeah, we have two. You have two. You have 477.
We tended to take your testimony of HR 477 and 3971 in the same vein, and it is true. I do want to talk about appropriately after you leave, if you choose, what is called the CR bill, continuing resolution bill, but I think we spoke about, did you want to add any bit of testimony?
I had some talking points on 477, but it is not necessary for me. We will make sure that they're entered into the record.
That would be great. Without
Yes.
objection, of course, anything that will be into the record as the gentlewoman has provided. We appreciate it very much. Thank you very much. I hope
Welcome.
you both have an awesome end of your day. Is there any other member that would seek to give testimony? HR 477, HR 3971. We would now move to this close the hearing portion of HR 477, HR 3971. We'll move to the second section of the attempt that we have today that was discussed in my testimony, HR HJ Res 123, further in consideration. The committee will now consider House Joint Resolution 123, the Continuing Appropriations Act of 2018. This short-term CR will extend government funding through December the 22nd, 2017. This will provide this body and the Senate with more time to reach a long-term spending resolution to ensure that our troops and our military continue to have the resources as well as the overall funding of the government to ensure our interests in home and abroad are taken care of. Additionally, the CR addresses the Children's Health Insurance Program, known as CHIP, to ensure the program has the necessary funds to continue helping our most vulnerable members of our society, that are our children. Specifically, the joint resolution waives a proaction rule in the current statutory formula to give the Centers for Medicaid and Medicaid Services flexibility to allocate currently available redistribution dollars to any state that exhausts its federal CHIP funding. This change means that CMS can make states whole or allow them to be whole with federal dollars through December 31st, 2017, even if a state has already received its original share of the redistribution funds under the current proration rule. This also extends the federal flood insurance program through December the 22nd, ensuring that those in flood-prone areas continue to be able to receive the necessary support for this program. So, this is a short, as we have said, bill that is very straightforward. It's a date change to December 22nd, which is a couple weeks from now. We'll fund the government and allow the House, the Senate to continue their work on these important activities. So, with that said, would anyone like to ask me any questions about this, or would we move forward and end this section, move to a resolution? I would open the floor up.
No question.
This is about the CR, sir. Well, gentleman's recognized.
Our first one is to amend to protect the Bears Ears National Monument. This is very important, not just for the state of Utah, but also as a precedent-setting bill. It's obviously of great importance to our native nations as well. I had the opportunity to meet with some members of the Ute tribe yesterday. This amendment is the language of an existing bill. It's nearly identical with Mr. Gallego's and my bill that would return the Bear Ears National Monument to its original boundaries. These changes that have been proposed by the president would all but erase this iconic monument. When this was established, the purpose was to preserve the sanctity of the land for our First Nations, to protect the public lands for future generations to enjoy. And I'm worried that this is the beginning of a potentially slippery slope that could roll back protections for many national monuments if Congress allows this to continue. And we can begin to stop that process by saving Bears Ears. So I would encourage the allowing a vote on the Polis and Gallego amendment, Mr. Chairman. And I have one more, if I may, Mr. Chair.
Yeah, gentleman's recognized.
My second amendment to the continuing resolution is the DREAM Act, similar to the language introduced by Representative Roybal Allard that I'm a proud co-sponsor of. This important legislation would allow DACA recipients to receive conditional permanent residency and someday earn their citizenship. We all know that this Congress is on the clock with regard to the status of our aspiring Americans because President Trump has announced that he's going to terminate the DACA program, which is a program created under executive order. So it'll fall to Congress to create a solution in law. The DREAM Act, I'm confident, would pass on the floor of the House if we can include a up or down vote as part of the continuing resolution. It would get the issue off the desk of Republican leadership and allow leadership of the House to focus on other priorities. And I think this is a great opportunity to be able to show a bipartisan win. My amendment does that. It has significant support from Democrats and Republicans. It would allow those today who came here to this country at a young age and were brought here by their parents and grew up in this country and know no other country, to finally rest easier knowing that they're no longer in danger of deportation to a country they don't even remember or know, perhaps even where they speak a language that the young people don't even speak. Americans across the board believe that Dreamers need to be protected, and that's why, Mr. Chairman, I ask that we simply allow an up or down vote with sufficient time for a debate on the floor. I'm going to request that we allow an hour on each side for debate. I know we often do 10 minutes, but at the committee's discretion, I think allowing an hour would be good to debate both sides of this. And again, I think the overwhelming majority of the House does support the DREAM Act. We can include it, a free up or down vote on the continuing resolution. It will simply help guarantee that 1 million aspiring Americans will have the chance to live and work in the country where their contributions are valued, the only country they know. And I ask the committee to make the Polis amendment for the DREAM Act in order as well, and I yield back.
Thank you very much. The gentleman is actually providing testimony. This would be testimony, just as I provided testimony on my portion. The gentleman was providing testimony on an amendment that he had
yes.
to that. And so the gentleman has done that. Would the gentleman open himself up to questions from the committee?
Of course.
The gentleman would open himself up to questions concerning his two amendments. Is there any committee member, Mr. Cole? No question. Is there any, the gentleman, Mr. Woodall?
Mr. Chairman, I was looking for our colleague, Rob Bishop, from his days up here. I heard my friend say that this was important to protect the state of Utah. I did not hear the name of the Utah congressperson that was co-sponsoring this amendment with him. Are there any Utah members?
Well, you know, I think if we advance to the floor, we can see which Utah members vote for it and against. I mean, the Congress hasn't been asked the question yet, you know, so we don't know where different members stand.
I don't know, but I thought since you...
I don't know where different members stand. The only way to find out would be to allow a up or down vote.
Fair enough. I yield back, Mr. Chairman.
Thank you very much. Is there further? Yes, sir. Gentleman, Judge
Polis.
You're
Is it,
recognized.
Mr. Polis, you said you spoke with the Ute tribe.
Yes.
Did they discuss with you the 100,000 or more historic sites or artifacts that are important to the tribal communities?
They did, and they also expressed the grave concern that without these protections, many tribal artifacts had been looted in the past before these protections were put in place, and they were afraid that that kind of looting would begin again if those protections were removed. And they emphasized the importance of preserving the boundaries of the national monument.
And on your other measure with reference to the Dreamers, do you have a thought as to what legal status they should achieve and how that should work out?
Yeah, and what we do in the DREAM Act, which I know the gentleman joins me as a sponsor of, and I want to be clear, this doesn't give instant citizenship to anybody. And that is not what Democrats are proposing. That's not what Republicans are proposing. It simply creates a way where people who only know this country, who've been here from a young age, can get in a line that would be created that would someday allow them to earn citizenship. There's a provisional status for a period of time. Then they would become green card holders for a period of time. And only after being green card holders for a period of time would they even be eligible for the citizenship. I'd have to look at the math. I think it's somewhere in the 10 to 12 year time frame before the very earliest any of them could even take the citizenship test and become citizens. In practice, for many, it might be 15 years, it might be 20 years. So it creates an orderly line, a legal way, where people who are legally able to work today, they're legally able to work today on deferred action, would still legally be able to work after DACA is repealed, and eventually they would be eligible to take the test of citizenship, and if they pass that, be able to become citizens in 10 plus years.
I'm pretty sure a significant number of them will be able to pass the test in light of the fact that in my district, 3 of my high schools valedictorians are Dreamers.
Yeah.
And I think they'll pass the test pretty good of not only meeting all of the requirements, but I think it's even too long. I agree that there should be a line, but we need to address comprehensive immigration in this Congress. With that, Mr. Chairman, I have no further questions of Mr. Polis, but I would have a question of you with reference to the CR, if you would permit.
Yes, sir. I'm going to finish the.
Yes.
Yes, sir. As you alluded to, we're now going to ask and allow the committee to ask any questions to Mr. Polis of his two amendments. Is there any member that would seek time with the gentleman for a question related to his amendments? Seeing none, gentleman from Washington.
Mr. Chairman, thank you. I don't really have a question, but just to make a statement about the Mr. Polis's effort to add the DREAM Act onto this continuing resolution. Yeah, and I would caution that, or just throw out the thought that there are a large number of people on both sides of the aisle currently working on this particular issue. A lot of effort is going into finding a balanced solution that people on both sides of the aisle can support. And I would just submit that it's, in light of that work going on, that to amend something as important as this, as I agree with the gentleman from Colorado, these young people are outstanding members of our communities around the country and are contributing a great deal to each and every one of our communities, and we do need to find a lasting legislative solution to their predicaments. And in light of the work that's going on there, I would submit that this is an issue that can stand on its own merit, that a bill that would be able to come forward in front of the Congress would be able to do that, and that to add it to a continuing resolution, at least today, in my mind, is not the right move. So that would be my statement, Mr. Chairman. I do appreciate the gentleman's effort, and certainly agree with many of the things that he said. But to me, this is not the right vehicle.
If I can respond, Mr. Chairman?
Thank you very much. Yes, sir.
You know, I would view that this amendment is part of that effort, you know, and I think, again, it would be nice for Republicans and Democrats to get this taken care of. I do think the DREAM Act has the votes to pass. I don't think that's ever been in question, that this body could pass the DREAM Act. I also want to thank, this was not set up ahead of time, but it so happens that I have a meeting with some Dreamers who are the ones who just came in the room, and I just wanted to welcome to our committee Cecia, Gladys, Javier, Martha, Carla, Caitlin, Christian, Maria, Anna, Adriana, Fabiola, and Caitlin. We're so excited to have you here. I just offered the DREAM Act as an amendment to the continuing resolution to allow a pathway to citizenship for young people that were brought here at a young age, and I'm hopeful the committee will adopt that. And again, the efforts, as the gentleman from Washington indicated, are ongoing. I think that this committee right now has the opportunity to solve it and to do our part, which is not to pass the DREAM Act into law, but to refer it to the full House, just to allow a vote. Where I am confident it has the votes in its present form by a reasonable margin to pass. Thanks again to the Dreamers who continue to make sure that members of Congress are educated and aware about their everyday battle to be able to work legally and remain in the only country that they know. And I yield back.
Thank you very much. Is there anyone else that would seek to offer questions to the gentleman? Seeing none, this would satisfy that side. We'll now move to the section that might be considered the CR. Before I do that, I would like to recognize that we do have a number of students that are here and who have taken time to not only come to the Rules Committee, but have come to Congress to express their ideas, and I want to acknowledge that you have brought those students here. And I would like to, before we go to the second part where I am, the gentlewoman, Mrs. Slaughter, the ranking member, would like to be recognized for the purpose of making recognition also. The gentlewoman's recognized.
Thank you very much, Mr. Chairman. I've got three of the most extraordinary interns here today that are going to be leaving us very soon, and I want to introduce them to you. Emma Coughlin. Emma is a master's student in Media and Strategic Communication at George Washington University. She grew up in the city of San Francisco, received a bachelor's degree in political science and a minor in art history from the University of California, Los Angeles. She has done extraordinary work in communications. Samantha Maston currently a senior studying international relations at American University. She grew up in Henrietta, New York, in my district, is interested in foreign affairs, has done amazing work on that, specifically transatlantic relations and security, and Kevin Orsini. Kevin's a recent graduate of the London School of Economics with a master's in human rights. He's a Rochester native, received his bachelor's degree in international relations and history from Canisius College in Buffalo, New York. And I know that all of us, because of our wonderful interns, and appreciate that all of you go on to do such extraordinary things. You give us so much. We hope that you can take away something of value as well. Thank you very much for your work and best wishes for your future. Thank you, Mr. Chairman.
Louise,
and welcome to the Dreamers.
Yes, Louise, we do welcome the gentleman, the young man Kevin, who London School of Economics. Yeah, that's a pretty high standard. So we recognize that also. You know,
they've all done extremely well.
I walked in here today and had a chance to meet my son Bill, who is a third-year medical school student at Texas Tech University Medical School, and his beautiful girlfriend, fiance, I'm not sure which it is entirely. I've got to be careful how I speak this. Well, I do have to, because I think I know some, but I don't know it. Anyway,
you don't mess around.
No, I don't. So he left me a note here saying, Dad, thank you. It was good to see you. So we get reminded occasionally. Well, that was Nicholas.
I saw Nicholas.
Yeah, Nicholas was on the replay. Big old smile back there. But Bill had to head back to medical school. But we're reminded of how special, and Kevin's parents, I know, are proud of him too. So.
As well as those girls.
Yeah, well, she's from Henrietta or wherever in the.
They're going to make a major difference in this world, and I'm very proud of them. And I do know Adam Berg, too, who was well-schooled, as you know,
yes.
in the Rules Committee, and then deserted us for appropriations. We're sorry about that, a little bit ashamed of it, but.
Well, he can come back here for good theater.
It's nice to have you here.
Yeah. Adam, good to see you again. Okay, so what we're looking at now is the end of the Rules Committee hearing, but you're now going to get to see, or they get to question me, because I'm the witness. Mr. Polis could have been down at this table, chose to be there to give his testimony on this, what is called the continuing resolution bill. I now have told the members that it's a date change. We're going to add the CHIP funding, necessary requirements, and that it would go to December 22nd. Short bill, easy concepts, but I would open myself up for any question that members of the committee may have for me, as I'll be the expert witness on this.
Mr. Chairman?
The judge, you're recognized.
Acknowledging that there may be others, Ms. Law.
Well, there might be.
Yeah. Well, in any event, Mr. Chairman, you've had 3 months to write your spending bill since the last CR, which followed a different CR from April. And you control the majority, or does, the House, the Senate, the White House, and yet you're here today seeking more time. Now, earlier this week, and I said that in my opening remarks when we began, Ranking Member Lowy of Appropriations made this statement: I'm eager to know what Republican leadership believes they can accomplish in the next 2 weeks that they haven't been able to accomplish in the last 2 months. And I'd like to pose that same question to you.
Good. You have 2 members of Republican leadership that are present right now. I myself sit in Republican leadership, and the gentleman, Mr. Collins, from Georgia, sits in Republican leadership.
When did he get in?
Well, the answer is he sneaked in.
Nobody wants to talk about it.
The answer is
thank you for telling me that.
Sneaked in.
Yeah.
So
I'll be nicer to him.
I would start. That would be a great thing. So, do you have a question for myself, or do you have a question for the gentleman, Mr. Collins? I'll be glad to answer for us.
Well, I've posed that question to you. What you going to do 2 weeks from now? Okay. Mr. Chairman, people don't complain all the time to the leadership, but we complain to each other. It's the holidays. And a lot of people don't like to say what is pretty obvious. We're going to leave here at some point, come back on the 22nd, and I guess what I need to know from you is, can you assure us that this is going to be the last CR of the fiscal year?
The gentleman asked a very good question, and I will tell the gentleman I wanted us to solve our funding issues on September 30th. I want and need any organization, but especially the federal government, to take its resources that this body decides, and we have been through these spending bills. We've been through the budget, we've been through the appropriations bills. I believe it's vitally important to offer any organization that's as large as the federal government to tell them the rules of the game and the money and let them manage what they're supposed to do for the best interest of the country. This is in particular necessary as we deal with non-emergency, but issues in FEMA and the Corps of Engineers and a lot of other agencies that have important work to do. More importantly, the Pentagon needs a chance to run the military budget, the CIA, their intelligence budget, and NSA, those important activities. So I would be the first to say to you, I wish we were doing it. I wish we'd done it several months ago. Is this going to be the last time when we move this front to December 22nd? It is my hope, and it is not my promise, but my hope that you have seen a good bit of conversations that has taken place, not only among our members, but with our leadership. I have expressed my opinion several times, but we're trying to do this also with the United States Senate. And so we're now trying to work through what would be one important bill, and that is the tax bill, and I think a lot of issues are now turning to this. So yes, I would say, in my opinion, it would be my best opinion that December 22nd, we better come up with an answer, because I think that after that, and I've stated this publicly, I think after that it presents problems for a number of people, including the United States military, unless we find a way to fund them completely.
Well, let me tell you what I think, Mr. Chairman. I think we are debating another CR because instead of working together to address the needs of our country, your party chose to ram through the partisan tax bill. And you did that without any hearings and with a process that was completely closed off to Democrats. The Senate bill wasn't even typed up in all of its particulars. It had notes scribbled on it, and people are still talking about that. So no one in the Senate can even say with honesty that they read it. In the end, the legacy of the tax bill will speak for itself, and it'll speak to the values that your party has come to espouse. Now I'm looking ahead. It is fortuitous that the young persons who are here, I don't know that they're all students or students and working people, I would believe. I had already indicated that 3 of my high schools in the congressional district that I'm privileged to serve had young people that are dreamers as valedictorians. And I might add, that's not the first time. The president has ended DACA and said that it's up to Congress to pass a permanent fix. Now, the lives of 800,000 or more young people needlessly hang in the balance. We also need to address temporary protected status for Haitians, Nicaraguans, El Salvadorans, and Hondurans, and other nationals taking refuge in our country. Haiti is still not recovered from a hurricane, an earthquake, and an ongoing cholera outbreak, and it cannot absorb tens of thousands of people. Now, I've worked with our colleague, Republican Carlo Covello, who introduced a bipartisan fix to the temporary protective status. Can you assure me, Mr. Chairman, that the DREAM Act and the Espera Act will be moved in the coming weeks along with the long-term funding bill?
Thank you very much for your question, and I would respond with a reminder that we heard the gentleman from Washington, Mr. Newhouse, allude to that he believes that they're within our party that we, I believe, have been forthright about, including regular interactions with the media on the status of not only that working relationship, but towards the timing of that. I believe my party, going back some period of time that we have brought up a number of times, including Mr. Polis and yourself and the gentleman from Massachusetts and the ranking member who have brought up a number of times a viewpoint that this is of one of the highest priorities that you envision that the Congress should be achieving. I felt like that when the President gave us a deadline, it was something that we, as members of Congress, the majority party, yes, we're either going to adjust to and accept that challenge, or we were going to wimp out and not accept the challenge from Article 2, the President of the United States. It is my intent, and I have satisfied myself in as much as the work that I have seen that is taking place from a working group that is very serious, that includes members that would be a fair representation of the differing viewpoints that people may have in the United States Congress, yes, in the Republican Party, but viewpoints that I believe that would coincide with some of the ideas that might be shared by some of you on this committee. The facts of the case are there is an active working relationship that is expected to deliver a product, but I do not anticipate that will be by the end of the year that would be ready for us to move forward into a piece of legislation. But I do believe that the timing is that, and I have to be careful here because my words do matter. While I have no real control, I do have a vision and a voice myself. I'm encouraging us to get this done as the President had suggested we should accept.
And the President suggested March as the drop dead date.
I believe that is absolutely correct, and I believe that is what we're aiming at, and I would,
Well,
as I say that, I would look out to young people who are letting us hear their ideas.
Appreciate it very much,
along
Mr.
this. Yes,
Chairman, and I'm sure you understand the agony not only of those young people, but the others that I mentioned, the nationals that are seeking refuge in our country as well.
I would say, just as an attribute, and I don't take advantage of you when I say this at all, but there was a question, as you as a co-sponsor, that the gentleman, Mr. Polis, answered to remind us about what the legislation is. I think we all need to know what the legislation is that we're going to be voting on. And I think all the body needs to focus on it, and I think we will have several weeks devoted to not only testimony, but understanding this so that we speak about this in terms of the knowledge of what would be expected.
It's sort of like I said today, Mr. Chairman, about bump stocks. We don't need any study. We all know how many of these young people are here and the circumstances that they're confronted with.
That might be, but I mean, still engaging the gentleman, I would say to you, we're going to have to determine circumstances from those who may not have conducted themselves in such a manner, whether they would qualify, whether if we had someone that was seeking admission to this country from another country, we would expect a background check in some circumstances. And I think that that would still be appropriate. In my opinion, that would still be appropriate. So it's not so easy to say we all know the right answer.
You know something, Mr. Chairman?
Yes,
you and I were here, well, not in Congress, but you and I were active professionals when President Reagan allowed amnesty for the persons that were in the United States at that time, and it created no added problems for this nation, not in any respect. We live in the Western Hemisphere where many of our citizens and citizens that would be come from. Nevertheless, let me move on. Flood insurance is something that I know you know is of critical import to a lot of us. And the hurricane season was particularly devastating. and it underscores the need for reauthorizing the National Flood Insurance Program. Now we have the extraordinary fires that are ongoing, and you've heard me, Mr. Chairman, as well as other members here, talk about the fact that the Federal Emergency Management Organization has been handling more than just hurricane relief. They've had tornadoes, they've had floods, and we continue to kick the can down the road on many of these things. Will you commit to including the long-term authorization of flood insurance in the coming CR or any other long-term funding measure, Mr. Chairman? And that's my final question.
Yes, sir. And I thank the gentleman for his not only respectful but insightful and thoughtful answer. And the answer is that I believe it would be irresponsible for us to say that we have taken care of funding the government without the resolution of those two important programs to understand as we not only turn to a new year, but as we turn on the TV to see the fires that are raging in Ventura County. I believe it's Ventura County, California at this time. And I would say to you that it's caused quite a discussion, notwithstanding that I'm from Dallas, Texas. I know people that are from Houston. I know people that are serve in areas as members, and they represent people who need to know what next year is going to look like because they have to protect their homes. So I would think it would be irresponsible for me or my party to present a bill where we did not have some answer to address it.
I appreciate that, Mr. Chairman. That's all I have. Thank you very much.
Judge Hastings, thank you very much. Okay, is there, yes, sir.
Yeah, I just, on the CR, I noted that, I'm sorry, Mr. Chairman, I noted that it continues the CHIP funding for states that have exhausted their federal CHIP. I would just like to point out the situation in Colorado, and I think many states, is the CHIP money is not expired yet, but we are short to expire early next year, early next calendar year. I think that is where the majority of states are. The state that Mr. Buck and I hail from is in that category. So I just want to be clear that this CR for this 2-week period still leaves that uncertainty over what will happen next to the states that are going to run out of children's health money early next year. And it is very important that we incorporate the funding into the full end-of-year funding bill for the following year, because otherwise, it's my understanding that this funding makes no difference for when Colorado and the majority of states will run out, because it's scheduled to be early next year anyway. So I just wanted to highlight that. Secondly, I just wanted to ask, this goes through the 22nd, and does it maintain spending at the current levels of the existing across every agency? There's no changes?
That is what a CR does, until it specifically specifies, as it does in the CHIP program, about a reallocation that may take place, and extends that through the end of the year, I believe.
Great.
That would be correct.
And just in contrast, I mean, certainly, again, I think that, as the gentleman from Florida indicated, I think members on both sides of the aisle have had ample time to study the DREAM Act and other proposed solutions for years, frankly. In fact, a similar bill was even passed by Congress in 2010. So it's nothing new. It is the subject of a lot of legislative education efforts, and I think that all indications are it would have strong bipartisan support and pass if we're able to pass that along for an up or down vote. And thank the gentleman for his testimony, and I yield back.
Yes, sir, and thank you very much. Is there any other question that would be placed before us? The gentleman from
Yes,
Louisville,
Mr.
Texas,
Chairman,
Dr. Michael Burgess.
I do feel obligated to make a statement about the funding for the Children's Health Insurance Program. Of course, you know, Mr. Chairman, that bill, a 5-year bill, passed the floor of this House in a bipartisan fashion the first week in October. Yes, it is true that we did not meet the September 30th end of the fiscal year requirement. The work had been done in committee. We had waited because the Senate had asked us to wait. We had waited because committee Democrats asked us to wait to see if we couldn't come to a complete agreement. We were not able to.
The ranking member of the Energy and Commerce Committee.
That is correct. So I hope the gentleman from Colorado will discuss with his senators in his state that, yes, the House-passed bill is awaiting activity. It is the 5 years that the Senate asked for CHIP funding. I preferred a 2-year bill. I thought, well, when you pass the Affordable Care Act, you authorize the Children's Health Insurance Program to the end of fiscal 2019. I thought a 2-year funding would make sense, and then we could work on a longer reauthorization, because if you'll recall, we were told when the Affordable Care Act passed, we wouldn't need the Children's Health Insurance Program any longer because everyone would have the Affordable Care Act. Turns out we do need it, and I think it deserves I thought it deserved a more thoughtful approach than trying to get it done during this year. But we conformed to what the Senate requested. They passed in their committee a 5-year bill, 2 years at the Affordable Care Act level of funding, 1 year at sort of a step down from that, and then 2 final years at standard traditional SCHIP funding to give states a chance to ramp down their spending from the levels it had been bumped up to with the passage of the Affordable Care Act. This bill was offset. It was offset responsibly. The offsets were not unreasonable. There could have been greater agreement, but for whatever reason, the negotiations broke down. Still, there were members on on your side of the dais who voted for the SCHIP bill when it passed the House, and it has languished in the Senate. And I don't know why. I don't know why the minority leader in the Senate will not allow that bill to come up for a vote. I think they should have the 60 votes to cut off debate, pass the bill, and get that money to our states. Your state needs it. My state doesn't need it yet, but it will soon. We've exhausted some funds because of paying for the hurricane. I expect Mr. Hastings' state is in a similar situation. I don't know what the situation is in Massachusetts, but there are many states that are bumping up against their statutory limit on that. We have done our work on the House side. We have done our work, and it now is, it is actually this time truly the Senate's move next. Thank you, Mr. Chairman, for allowing me to get that off my chest. We spent a lot of time working on that in committee this year.
Well, the gentleman, as we know, the gentleman serves as the subcommittee chairman for health in his daytime job at the Energy and Commerce Committee, and I thank the gentleman. Also, the gentleman, Mr. Buck, has been interested in making sure that we're moving these things, has spoken to me a number of times. I know the gentleman from Colorado spoke to me about state-specific issues. The gentleman, Mr. Buck, the gentleman, for sure, Mr. Burgess, has been intensely interested in this, and it should be noted that while it might appear that we're a bit frustrated, we believe we have done good work and are asking to be met by our colleagues in the Senate. The gentleman from Massachusetts.
Yeah, and since we all want to go on the record here, I just would say some of us do have a problem with the way you, the offsets for CHIP, going into the prevention fund, which means immunizations, which means funding
and
for
vote
households.
no.
Yeah, I did vote no on that, and I thought it was a lousy offset. And what frustrates us is that we're spending time today on a stupid NRA bill that doesn't do anything to enhance the security of people in this country, that is basically an attempt to get more money from a special interest group. That's what we're doing today. Well, when we should be finishing up appropriations, we should be finding a way to come together on the DREAM Act, on funding CHIP, and so many other things. So the frustration level is pretty high based on the priorities that have been put forward by this leadership. And I thank the chairman. I yield back.
Yes, sir. Yes, sir. And with great respect, as the gentleman, whether it be Dr. Burgess or myself, we believe we are addressing issues. We bring those bills through to committee up here, and we believe we're trying to forthrightly move them, and I appreciate that. Is there any other discussion that anyone would choose to have concerning this CR? Okay, this closes the hearing portion of HJ Res 1, 2, 3, and the chairman will now be in receipt of a motion from the distinguished gentleman, the young chairman from Oklahoma.
Mr. Chairman, I move the committee report a structured rule for consideration of H.R. 477, Small Business Mergers, Acquisitions, Sales, and Brokerage Simplification Act of 2017. Rule provides 1 hour of debate, equally divided and controlled by the chair and ranking minority member of the Committee on Financial Services. The rule waives all points of order against consideration of the bill. The rule provides that an amendment in the nature of a substitute consisting of the text of Rules Committee Print 115-43 shall be considered as adopted, and the bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended. The rule makes an order only the further amendment printed in Part A of the Rules Committee report, if offered by the member designated in the report, which shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and unopponent, shall not be subject to amendment, shall not be subject to a demand for division of the question. Rule waives all points of order against the amendment printed in Part A of the report. The rule provides one motion to recommit with or without instructions. Section 2 of the rule provides for consideration of H.R. 3971, the Community Institution Mortgage Relief Act of 2017, under a structured rule. The rule provides 1 hour debate, equally divided and controlled by the chair and ranking minority member of the Committee on Financial Services. The rule waives all points of order against consideration of the bill. The rule provides that an amendment in the nature of a substitute consisting of the text of Rules Committee Report 115-44 shall be considered as adopted, and the bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended. The rule makes an order only the further amendment printed in Part B of the Rules Committee report, if offered by the member designated in the report, which shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and unopponent, shall not be subject to amendment, and shall not be subject to a demand for division of the question. The rule waives all points of order against the amendment printed in Part B of the report. The rule provides one motion to recommit with or without instructions. Section 3 of the rule provides for consideration of H.J. Res. 123, making further continuing appropriations for fiscal year 2018 and for other purposes under a closed rule. The rule provides 1 hour of debate, equally divided and controlled by the chair and the ranking minority member of the Committee on Appropriation. Rule waives all points of order against consideration of the joint resolution. The rule provides that the joint resolution shall be considered as read. Rule waives all points of order against provisions in the joint resolution. Finally, the rule provides one motion to recommit.
I thank the gentleman from Oklahoma. I would yield myself 1 minute. The gentleman that you have just heard, Chairman Cole, has offered the motion that is one rule, three measures, H.R. 477, Small Business Mergers, Acquisition, Sales, and Brokerage Simplification Act, structured rule, 1 hour of debate, makes an order, one amendment. It's bipartisan, motion to recommit. Second, H.R. 3971, Community Institution Mortgage Relief Act, structured rule, 1 hour debate, financial services, one amendment made in order. That is a Democratic amendment, and motion to recommit H.J. Res. 123, continuing resolution, that closed rule, 1 hour debate, motion to recommit. Is there, now that we have heard the motion, is there amendment or discussion to that? The gentleman from Colorado.
Mr. Chairman, I have an amendment to the rule. I move the committee make an order and give the necessary waivers for the following amendments to H.J. Res. 123. Number 1, with 20 minutes of time allotted for debate, and number 2, with 2 hours allotted for time to debate. If I may, Mr. Chairman. This would allow for full debate and passage of the DREAM Act and also for the Bears Ears National Monument Expansion Act. Again, I believe that we owe it to the young people affected to provide some certainty with regard to being able to work legally and remain in this country and earn citizenship someday. That's why the DREAM Act has strong bipartisan support. I'm confident if we pass it along to the floor of the House, it should be able to pass fairly overwhelmingly. I did, because of member interest, allow my amendment for 2 hours of debate, and I think that there will be a lot of people that want to, of course, speak for the amendment, perhaps even a few that want to speak on the other side. But if we can resolve this matter, I think it'll make all the end-of-year issues easier. We know there needs to be a CR or omnibus by the 22nd. There is a tax reform proposal that I know Republicans are working on. I think it would be a great opportunity for this House to remove the dreamers out of this debate and simply address that issue in a bipartisan way, advancing this as an amendment to the CR along to President Trump for his signature. So I'm hopeful that we'll allow those two amendments and look forward to, if they're allowed, to debating them on the floor of the House. Yield back.
Thank you very much. You've heard the amendment from the gentleman from Colorado in discussion. Is there further discussion?
Mr. Chairman?
The gentleman from Georgia is recognized.
I know my friend is sincere in his efforts and tries to add language such as this to so many different bills that come through this chamber. As you will remember, Mr. Chairman, we sat through hearing after hearing, produced all the appropriations bills on time for the first time in a decade. I'm sitting beside one of the cardinals who produced the first labor HHS bill that I've seen in my entire congressional career. We have put in the work to get this done, and this 2-week CR isn't supposed to be a major legislative initiative. It's supposed to answer the seemingly unanswerable question the gentleman from Florida asked, which is, if you couldn't get it done in 3 months in the Senate, why in the world are you going to get it done in the next 2 weeks? I don't know what the answer to that is, but I know that we made we made almost 500 amendments in order on this package when it moved through this House. We've got 3 folks from Ms. Slaughter's team leaving us. I don't want folks to think that we didn't invest time and hour and week and month into getting this package right. This is a continuing resolution for a spending bill. It is not an authorizing bill on any of these other bills that the gentleman wants. And I'm glad he made the effort to put more time in, should these amendments be made in order, because it would be a disservice to the size of those issues to put them on a simple funding bill like this. But to put the issue on there at all, I would tell you, not only threatens the ability of this body to keep the government open, which I think is an important priority, but also threatens the quality of the debate that we would have on the issue as well.
Well, the gentleman yield for a
Chairman, I would oppose the gentleman's.
We yield for a question.
Be happy to yield, my friend.
Again, the reality that we've been living over here just doesn't seem to correspond well to your remarks. We have not done most of the major appropriation bills that this Congress hasn't done them. I mean, I know we tried a couple of them, but most appropriation bills we didn't do. Secondly, I personally have had amendments blocked. I know that for sure. I had amendments I tried to offer to those appropriations bills, and they were not allowed out of this committee. So, I mean, I experienced that.
Reclaiming my time, I would share with the gentleman, and it's been an incredibly busy and productive session. So I don't fault the gentleman for not seeing it all. But we in fact passed every single appropriations bill, not just every single bill, passed every single bill for the first time since I've been here. That's why.
Are you referring to that week where we lumped most of them together into one bill?
No. Well, as folks will recall, we did a national security package and a domestic package.
Okay, so
it hasn't been done in 10 years. If folks want to denigrate it as opposed to celebrate it, it's okay with me. I'm good either way.
I've been here, 9 years now. I do remember when we had an appropriations process. It was Chairman Obey at the time was the Democratic chair. He would come down for each appropriations bill. There would be amendments. I think what you're referring to, which is a very different process and not one that is analogous to some sort of open process, is we put a bunch of bills in a practically an omnibus. Some called it a minibus. It was almost, I think it was, 2/3 of all the government spending in a week. And then we didn't even allow most of the amendments. So you can dress that up any way you want, but that's not this somehow open, normal appropriations process that Congress has done historically. Happy to yield back.
Again, reclaiming my time, I would say to my friend, he was able to vote on more amendments in this so-called perverted process that you've just described than he was able to vote on the entire 4 years of appropriations when Democrats led this institution. I just want to make that clear.
Well, the number of amendments depends on how many people offer amendments. So I offered amendments that were not allowed. I assure you, I'd be happy to reintroduce them, but I was very disappointed.
I make no effort I make no promise of resolving all of our differences in this forum. I'm only pointing out that this 2-week extension is only supposed to be that a measure to get us to that more powerful bill that I know my friend would like to be a part of. And I know his intentions are good. I just must oppose the gentleman.
Will the gentleman yield?
Be happy to.
Yeah, so we talk all about this wonderful process and all these amendments, but here we are doing a CR. And we're going to be here in a couple of weeks doing another CR. So, I mean, we can spin this all we want, and in the age of Trump, I mean, up is down, black is white, I mean, square is round, whatever. But the reality is that for however you want to do it, I don't think that this process is something we can all be proud of. It's really quite a mess, and here we are at the end of the session. I agree with the gentleman, and on the issues that he raised on the DREAM Act, I mean, come on. I mean, the idea that this is too important to be able to deal with right now, we've been trying to deal with this for months, and for years. So whatever. I mean, you can have your spin, but I just wanted to say for the record, this whole process has been a mess. And with that, I thank the gentleman for yielding, and I'll yield back my time.
I was happy to yield to my friend. I share my friend from Florida's frustration, but particularly with all the young people in this room today, it's doing a disservice to suggest that we have not gotten more done together in a collaborative way than we've gotten in a long time. There is a simple way to get this appropriations bill across the floor of the Senate. It's easy to do. All we need to do is have the Republicans in the Senate change the Senate rule to completely eliminate the rights of the minority, and we can get this done tomorrow. We'll get it done tomorrow. For my friend to suggest we have a majority would be accurate. To suggest we have control would not be accurate. We could abolish the rights of the minority tomorrow in the Senate and get this done, and we've chosen not to do it. Now, candidly, there's some disagreement about whether we should do it that way or not. But let's just be clear about why we're sitting here. We're sitting here because the House has gotten its job done, and Senate Republicans have refused to shut out the minority on the Senate side. And we can either be sad about that or celebrate that, but those are the facts as we sit here today.
Would you yield to me, Mr. Wood? This idea that you could just shut the minority out completely, as you have done here, and that you recommend being done in Senate, is that really what you think that we should do in this democracy?
Well, at reclaiming my time, as my friend from Massachusetts warned us about spin, as you heard me say very clearly, we did not do that in the Senate, and I am not proposing that.
But you have done that here. I mean, the rules have almost consistently, every one of them, been closed. We have not had amendments. I don't know what all these things are you're talking about.
Again, the gentlelady was a very successful leader of this Rules Committee when she led this Rules Committee. But just understand that our current chairman made more amendments in order on a single appropriations bill than you were able to do in your entire 2 years of final year as chairman of this committee. It's a hard job that the two of you have, and there's lots to be frustrated about. I just want to recognize successes when we have them. Perhaps we have them too seldomly, but we should celebrate them when we do.
Well, I don't want to speak for my colleagues here, but I feel pretty shut out. It's been a long time since we've had amendments.
Okay, we're ready to shut it out again then, I guess.
Yield back, Mr. Chair.
Thank you very much. By the way, this is this part of making legislation. I'm proud that our students are here to see this. We have an amendment on the floor, the Polis Amendment. We've now debated that amendment. I would offer the information. We're on a vote. That time is running out, and so we're going to move forward with the Polis Amendment. Those in favor of the Polis Amendment, signify by saying aye. Aye. Those opposed, no. No. Noes have it, noes have it. Gentleman asks for roll call vote. Clerk will poll the committee.
Mr. Cole? No. Mr. Cole? No. Mr. Woodall? No. Mr. Woodall? No. Mr. Burgess? No. Mr. Burgess? No. Mr. Collins? Mr. Byrne? No. Mr. Byrne? No. Mr. Newhouse? No. Mr. Newhouse? No. Mr. Buck? No. Mr. Buck? No. Ms. Cheney? No. Ms. Cheney? No. Ms. Slaughter? Aye. Ms. Slaughter? Aye. Mr. McGovern? Aye. Mr. McGovern? Aye. Mr. Hastings? Mr. Hastings, aye. Mr. Polis? Aye. Mr. Polis, aye. Mr. Chairman?
No.
Mr. Chairman?
Clerk will report the total.
4 yeas, 8 nays.
The amendment's not agreed to. Not agreed to. Further amendment or discussion? Seeing none, then we'll now move to the, as we remember, one rule. Those in favor? I'm sorry, did the gentleman announce the vote?
Yes, Mr. Chairman.
I believe the gentleman did. Okay. I need help. Your help is welcome. That's okay. Okay, we're now going to vote on the motion from the gentleman, distinguished young gentleman from Oklahoma. Those in favor signify by saying aye. Aye. Those opposed, no. No. The ayes have it. The ayes have it. Roll call, please. Gentlewoman asks for roll call vote. Clerk will poll the committee.
Mr. Cole. Aye. Mr. Cole. Aye. Mr. Woodall. Aye. Mr. Woodall. Aye. Mr. Burgess. Mr. Burgess. Aye. Mr. Collins. Mr. Byrne. Aye. Mr. Byrne. Aye. Mr. Newhouse. Aye. Mr. Newhouse. Aye. Mr. Buck. Mr. Buck, aye. Ms. Cheney. Ms. Cheney, aye. Ms. Slaughter. No. Ms. Slaughter, no. Mr. McGovern. Mr. McGovern, no. Mr. Hastings. Mr. Hastings, no. Mr. Polis. No. Mr. Polis, no. Mr. Chairman.
Aye.
Mr. Chairman, aye.
Clerk will report the total, please.
8 yeas, 4 nays.
The motion is agreed to accordingly. The gentleman, Mr. Woodall, will be handling this for Republicans.
And I for the Democrats.
And Mrs. Slaughter will for Democrats. Before we ask the question, I'll answer it for Judge Hastings. We do not anticipate any more meetings this week. The committee is done with its work for the week. Thank you very much.